and I'm also a family lawyer here in Austin. I've been practicing for 18 years, exclusively family law, and all in Austin, and I'm also board certified in family law and handle all aspects of divorce, modifications, child-related issues, premarital agreements, adoptions, etc. So, the purpose of the webinar is really to give some really good general information about divorce and that process in Texas. And although we are three attorneys giving some general information about the divorce process, we aren't giving any legal advice specifically for your situation. So, it's still very important to meet with an attorney and get advice about your specific
Good morning and welcome. We are here to talk about divorce basics, and these are my friends and colleagues, Amanda Andrae and Melissa Williams. I'm Cristi Trusler. We're all three divorce attorneys in Austin, Texas, and we're putting together a webinar to help educate our clients about the basics of divorce, what their options are, and some of the common questions that we get. So you may see some outfit changes, that kind of thing. We're trying to put together an in-depth webinar, and this will be over a series of different discussions that we have. So as I said, my name is Cristi Trusler. I have been practicing divorce law in Austin since around 2000, and I'm board certified in family law, which means I'm specialized in the area of family law. About 90% or better of my practice is divorce. I also do a lot of custody work, and just happy to be here today, and I'll turn it over to Amanda.
Thanks, Cristi.
Just as you drink your coffee.
My name is Amanda Andrae, and I have a firm here in Austin, Andrae Law PLLC. I'm also board certified in family law, and that's my entire practice is family law related. Everything from divorces, custody modifications, terminations and adoptions, and a lot of mediations as well. And I've been practicing for about 12 years in Austin and have only done family law. Melissa?
And my name is Melissa Williams, and I'm also a family lawyer here in Austin. I've been practicing for 18 years, exclusively family law, and all in Austin. And I'm also board certified in family law and handle all aspects of divorce, modifications, child-related issues, premarital agreements, adoptions, etc. So the purpose of the webinar is really to give some really good general information about divorce and that process in Texas. And although we are three attorneys giving some general information about the divorce process, we aren't giving any legal advice specifically for your situation. So it's still very important to meet with an attorney and get advice about your specific the specific facts that you have. And what we aim to do is give you a general overview and sort of an introduction to the process and help you make decisions in the very beginning as you look at whether or not you may be getting into the divorce process.
So one question we get pretty frequently is, how do I start the divorce process and kind of how it works? And so from the very beginning in Texas, one party typically files a petition for divorce, and that basically is a request to the court to have a divorce. When that petition is filed, there is a 60-day time period that has to elapse before a divorce can be granted. Most divorces don't get done in 60 days. There are a few that do, but you have to wait at least that 60 days with very few exceptions. There are exceptions for domestic violence cases. I personally have never filed one of those exceptions. I don't know whether Melissa or Amanda have.
No.
I haven't.
But that's fairly new. I think that came into being in the last legislative session. But so you file a petition. Those are usually pretty basic. Sometimes they can be more complex if you're asking for a temporary orders hearing, if you're asking for someone to be kicked out of the house because of a domestic violence situation or things like that. But the vast majority of the petitions that I file in my office are very basic, 2 to 3 pages, and simply asking for a divorce. And then from there, we decide, okay, how is this divorce going to be handled?
And one of the things that goes along with filing that petition in Travis County and many counties in Texas is a standing order that is put in place. It's kind of a mutual injunction, basically, to both parties. That's the court is saying, don't do all these things. Don't harass each other. Don't cancel each other's health insurance. Don't affect the utilities. Don't go out and buy a new car or get yourself in new debt. And then it lists things that you're allowed to do, like you're allowed to spend money for necessities. You're allowed to spend money on your legal fees. But it's kind of a, okay, everybody behave through this process. And it's in effect until the divorce is finalized. Some counties actually don't have that, so a lot of times we will actually request the court to put that injunction in place if the county doesn't have it as an automatic order that gets put into effect when we file the petition. Just depends on the county.
And I think I believe Williamson County has one, Bastrop County has one, Hayes County has one, and Travis, I believe Dallas County also has one. Williamson is the one that does not, but usually if you ask for those things and you at least have a lawyer who's been doing family law for a while, you're going to get that usually by agreement because the judge will grant it.
Right. And the purpose of that is really to maintain the status quo so that no one's doing anything funny or things are happening that one spouse doesn't know about while we sort things out, start getting information, and figure out the divorce issues. And so it just kind of puts a hold on everything while we figure and sort things out.
And I think one of the biggest things, I don't think you mentioned this, but is with the children. You cannot unenroll the children from a school where they are enrolled without, of course, with the agreement of the other parent, you can do that. But that is one of the big parts of the standing order is you can't leave the state with the children, and you can't take them out of their school or daycare.
Mm-hmm. And we do get agreements during that period where the divorce is pending to allow parents to travel with the children, for example. But we tell our clients, don't unilaterally make this decision. You need to make sure we have an agreement on it before you do anything that would violate that standing order.
Okay. So one common question that we get is about legal separation, and we don't have legal separation in Texas. We have the 60-day waiting period that Cristi referred to earlier that's mandatory, but in Texas, the divorce, all assets are divided as of the date of divorce, not date of separation, and so there really is no such thing as legal separation. When you file a petition for divorce, and so you have a divorce pending, you're subject to a standing order if your county has it, that Cristi talked about earlier as well. But other than the standing order restrictions, there really are no specific guidelines for legal separation in Texas.
So the other question that goes hand in hand with the idea of a legal separation is, well, now that we've filed a petition, is our money's now, my money's my money and his money is his money. but that's not the case. Texas is a community property state, and your earnings from your income is community property, and it remains that way basically until the divorce is finalized. And a lot of people have the idea that, well, if I've had a separate account all these years and I've put my paycheck in a different account and then I just pay the bills, so isn't that money mine? And that's not usually the case. So there is separate property. Texas there's ways to protect your separate property through the divorce, but it's the presumption is that everything is community.
I will have people that come in sometimes that think that on the day they got married, everything became community, and that's not really the case. So if you had assets before the date of marriage, those are your separate property. If you've been given gifts, that's your separate property. And if you've gotten, most of the time, a personal injury award is separate property with few exceptions, basically, unless it was for lost earnings. And what's the area that I'm forgetting?
Inheritance,
yeah. So inheritance is separate. So, and commingling those things doesn't turn them into community property. But if you can't prove it, that it's your separate, then it's going to be presumed by the court to be community.
So one of the first things that people are wondering about or looking at when they do make the decision to get a divorce is, how do I go about doing this? Which process is the right process for me? So we're going to summarize several different processes, give you an overview of them, starting with people who want to represent themselves, and we call that do-it-yourself divorce. And that would be where attorneys are not involved on any level, and the people want to represent themselves and do their own forms and do everything on their own without attorneys. And then another method we like to call kitchen table is where people can reach at least part of an agreement on their own, sitting down, talking about the issues, and generally coming up with some of the big picture issues that they can agree upon. And they may still get attorneys involved to help them iron out the details, or one party may hire an attorney after that. Mm-hmm. But this is a category of people who want to reach at least some of their agreements on their own.
The other areas, there's litigation, of course, that I'm sure everybody is familiar with. There is collaborative law, which is a very specific process. There's a roadmap we follow. It's a very unique way of handling your divorce. I think that it requires a high level of trust, really, between the parties and the attorneys and all the professionals that help the people through it. And we'll go into that more later, I think, more detail. There's also mediation. And mediation is one of those things that can be used in any type of divorce. You could go to mediation in a do-it-yourself divorce, or in a kitchen table, or in a collaborative case, and in litigation. And in fact, in Travis County, you go to mediation before you go to a final trial, and you try to settle it in mediation. And then there's what we refer to as cooperative. It's not necessarily... it's not a...
It's not a formal process.
Yeah.
I mean,
yes.
with collaborative, and sometimes people come in and are confused by that with me. They'll say, well, I thought you were a collaborative attorney. It's like, well, I am, but you didn't sign a collaborative contract. Your spouse didn't sign a collaborative contract with you. So it actually takes you out of litigation in a formal manner. And it's a form of alternative dispute resolution, just like mediation is, whereas cooperative is just kind of a
goal.
A slang.
A goal to stay out of litigation.
Right.
The parties don't want to end up in court.
Right. Maybe they don't want to sign on to the collaborative process, but they want their case to be handled that way. They want to handle their divorce in that same type of manner, where they're focusing on their interests and their values and goals, and they're forward-looking, and they're being transparent and sharing information, but they maybe don't want to take the step of signing a collaborative participation agreement, hiring the whole team, and and so we call that cooperative, but it's not in a statute or anything like that.
And I think that cooperative usually works better when you do have attorneys involved and you have two attorneys that trust each other and have worked together in the past. If you have a lack of trust or animosity between the attorneys, I think trying to do it cooperative gets really expensive and frustrating.
Mm-hmm.
So,
and it can take longer.
Right. You end up with these $1,000 plus letters between the lawyers that nobody really likes. So.
Yeah. But even in litigation, I think it's important that the attorneys have a level of respect and trust for each other, because if they don't have that, I think it can end up costing more money and more time to the clients, because we're having to do more work, we're having to do more discovery, we're having to take steps to protect our client because we don't know and we can't trust that the other side is being honest and open and sharing information. So even in a litigated case, some people have to go to court because they can't agree on the kid's schedule, and they both believe that it's in the kid's best interest to do this schedule over here, and one says this schedule over here, and so we end up having to go to court over that, or they can't agree on child support. But even in those situations, having attorneys that can work well together makes a huge difference in how long it takes, how much it costs, and just how difficult it is.
Mm-hmm. I would say that's a really common misconception that clients have when they first come in, that they think they will get a better deal if the attorneys are very adversarial with each other. Mm-hmm. And in my experience, it's the opposite. Mm-hmm. People really do have a more efficient process and usually a better outcome if the attorneys can cooperate, which mm-hmm. doesn't mean you're not advocating for your client. You mm-hmm. certainly are advocating for your client's interests, but there's not the additional layer of fighting between the attorneys.
Right.
Unnecessary fighting.
Well, and it's probably worth mentioning, I think more than 90% of the divorce cases that get filed end up settling. Most cases don't go to mm-hmm. a final trial. Mm-hmm. And if I think back on the recent cases that I've taken to court, they haven't been cases where I am on super good terms with the other lawyer. So, and that's probably true, I'm guessing, for all of us, that most of the time if we have a colleague that we respect and trust and can work with, we're going to get the case settled. We might have one or two hearings, maybe, but most of the time it will settle.
So as an example of what we're talking about, the three of us regularly take cases against each other. We're all separate businesses and operate independently. We don't practice law together. So at any given time, I may have a case with Cristi on the other side, with Amanda on the other side, and we've never had to go to court on a case that we had with each other because we're able to resolve those for the clients. And if the clients wanted to go to court, if they were insistent on going to court, of course we would, but it's much more efficient and effective for the client if we can help them reach an agreement and get them divorced quicker.
Mm-hmm. So one of the options for handling your divorce is to attend mediation. And folks often don't understand how that works, which is why we're going to explain it to you today. Mediation is a process where you have an attorney who is trained as a mediator, who basically facilitates an agreement between the parties. Typically, you each have an attorney present at the mediation, and then there's a third attorney who is the mediator. And normally we do it what's called caucus style, which means the husband and his attorney is in one room, the wife and her attorney is in another room, and the mediator is the one going back and forth. Often I mediate quite a bit, and often I will have an attorney meeting where I'll pull the two attorneys out and say, okay, let's talk through this issue because we seem to be at an impasse, and let's try and see how we can help the parties work through this. It is a very successful process. the cases that I mediate, it's a high rate of settlement. It's over 85% probably, where the folks end up at the end of the day or night sometimes signing what's called a mediated settlement agreement, and that agreement is then used to draft a final decree of divorce, a final order, whatever it is that's needed in the case. What am I missing about mediation?
Mediation is required by some counties. I think Cristi touched on that earlier. Travis County, for example, before you can go to trial, you're required to mediate. And the purpose of that is to encourage or force people to resolve their own disputes without, letting the judge decide and taking up the court's time. And so you're required to mediate in Travis County before you go to trial.
Right. And I think one thing that I think clients like about it is they still have some ownership over their agreement. They're not being told what to do by a judge or being forced by their lawyer. It's you're getting educated about your options, and hopefully by the time you get to mediation, you've gathered all the information that you need to know to be able to reach a settlement, and you can walk away with a binding,
Enforceable,
irrevocable deal. But that being said, I think it's important for people to realize that it is binding and it is irrevocable. You do still have confidentiality. The mediator will not take anything into the next room that you don't approve to be taken. But I think that's why it's so successful, is that it gives people a more relaxed environment, and
everyone focuses their attention on solution, on resolving the issues.
Right.
And one important thing about mediation is that if you are representing yourself, you really need to get the advice of an attorney before you go to mediation. As Cristi said, once you sign a mediated settlement agreement, it's almost impossible to get out of that agreement. So you want to have your legal questions answered before you go to mediation.
Right. And the mediator, who typically is an attorney, they don't have to be. I don't know when I last went to a mediation with a non-attorney mediator, and I typically won't do it. I think it's very wise to get a family lawyer mediator for a divorce or custody case, but that lawyer cannot give you advice. If you're there by yourself, the mediator will not give you advice.
They can't answer your legal questions about your case.
And I think all three of us do mediations. All three of us take cases to mediation as the lawyer. But having been in situations where someone is unrepresented, it's difficult as a mediator, because
It is.
the lawyer, you may want to tell them, don't do that, or that's not a good idea, but you really can't.
No. Your role is to be a neutral.
Right. Another important thing about mediation is the timing. Some folks come in and say, well, let's go to mediation. How soon can we go to mediation? Well, you don't want to go to mediation without having done your information gathering. Whether you do that informally, just by agreement, whether you have formal discovery and depositions, you need to have exchanged documents, have a picture of what the estate is, if you're dividing your estate, and just have all the information. I mean, if there's questions about what's best for the kids, and we've never even been separated, we're still living in the house, it might be hard to come up with a visitation schedule if you've never tried anything with your kids. So the timing of it is important. I get cases that come to me for mediation that just filed suit and they haven't even exchanged information, and we end up exchanging information at mediation. And I'm not saying those can't settle, but it's more unlikely that they're going to settle when there's questions.
Right.
You have to be able to make an informed decision. So if you don't have the information to make a good decision, you can't reach an agreement.
Right. And a lot of times you can terminate the mediation and then come back and complete it once the information is gathered. It's just preferable and more efficient if you can have all of that information collected before you get there. And another really common one, I think, for me is knowing what the other party makes and knowing what your budget is. So if you don't know how much it's going to take for you to run your post-divorce household, it's going to be pretty hard to talk about child support. So we've talked a little bit about cooperative already. Another term I use for that sometimes is negotiated, but I think what we covered pretty much is that topic. So I think the next logical option to talk about is collaborative law, and that's something that all three of us do. As I mentioned earlier, it is a formal alternative dispute resolution. We actually have a statute in Texas. I don't know if there aren't very many other jurisdictions that do have a statute, so that's nice that we have that, and it gives us a framework for what it means to have an official collaborative case. So the first thing is you have to reach an agreement that you're going to handle your case that way, and basically it's somewhat similar to mediation in terms of the clients having ownership over their process and over the agreement, but we chop it up. We're not in a full day or a half day mediation session. Instead, you are going to go to a series of 2-hour meetings. There will be agendas for each meeting. There will be minutes taken by the lawyers at each meeting. Both parties do have to be represented by a lawyer.
By a lawyer who's been trained in collaborative law.
Right. Well, the statute doesn't require that, but I think all three of us would very much encourage you to consider, if you're going to opt for collaborative law, that you get someone who's trained and who actually practices a lot in that area. There are unfortunately people out there that use it as a marketing device to try to get people in the door, and then as soon as they come in, they'll try to talk them out of it. So it'd be like saying I need to go get heart surgery and visiting a podiatrist or something. You don't probably not a good idea. So the first part of setting up a collaborative case would be to talk with your spouse about it, or have your lawyer send a letter over to their lawyer or to the spouse if they are representing themselves at that time, and invite them to do that.
I think another important piece of it is you can't force your spouse to do collaborative.
Right.
It's which is different than probably all the other situations, because mediation, you can actually get a court order saying you must go to mediation. Now, you still can't force somebody to be there in good faith and negotiate in good faith, but you can't force your spouse to sign a collaborative participation agreement, and no judge would force somebody to do that. And I believe that not everybody can handle their divorce collaboratively. I think it takes a certain level of emotional intelligence to handle your divorce in a collaborative manner. Transparency is one of the most important tenets of it. Is you're committing to be open about information and exchanging information and answering questions honestly, and we do it in a group meeting, in a joint session. So it's unique in that, and it's also unique in that we hire a financial professional who is part of our team, and a mental health professional who's part of our team, and so there's 6 of us at each of those joint sessions, and we're all following the agenda, we're all following the process and the steps. It's run like a business meeting.
Right, and it's not adversarial. I think that's important to point out too. If you're someone that's thinking, I want my lawyer to fight for me, that collaborative law is not about fighting. Your lawyer is, in a sense, fighting for you or advocating for you by meeting with you ahead of time, preparing you, educating you, and talking through what a situation might look like if it were in court. Nobody can predict exactly what a judge would do, but we've all been in hundreds of cases. We've been to court. We've been through been through lots of collaborative cases, so we know what the realm of possibilities are. And so I think a lot of times what we try to do, or what I try to do with my clients, is just sort of gut checking for, okay, this is, if you weren't in a collaborative process, this is the sea of options of what a judge might do.
And the defining feature of collaborative law is that you agree you will not go to court. And so you sign a written agreement in the very beginning of your case that you are agreeing to continue to meet and resolve the issues in your case, and you will not set any court hearings, and you exclude litigation as an option in your case. And that's the defining feature of collaborative law, is that it's a commitment to find solutions to your divorce issues.
Right. So if a party decides they do want to go to court, both of the lawyers actually have to withdraw by the statute, and you would have to get a new lawyer at that time. A lot of the people that are sour on collaborative law, the professionals, will try to tell you that that's the reason not to do it. I don't really have a lot of heartburn over that, and I don't think Melissa and Amanda do either. They can tell you, but I think since starting to handle collaborative cases back in 2002, which is when it sort of came to Texas, I've only had 5 cases that opted out. I haven't had one opt out since 2008. My first 2 that opted out were cases where we didn't use a full team, meaning a financial professional and a mental health professional. Since we in Texas have started doing that, I think even fewer of the collaborative cases tend to opt into litigation. But I don't see that at all, as a reason for not doing collaborative, because there are many divorce lawyers in town, and I'm not the only one. I can certainly refer you, to someone else if your case were to be in that less than 3% that opted out.
Right. And the process works. I think what we have figured out after doing this for more than 10 years in Texas is that the collaborative process is very effective. And it does work if you have 2 people who really want to come up with solutions for their family. And very few, I've had fewer than 5 opt out, and I've been doing it also since 2001, 2002. So it really does work.
And I think I've had 2 cases that got out of the collaborative realm and went to litigation, and one was domestic violence. For the most part, I think people that use the collaborative process are happier with their outcome, right? Because they've come up with usually really creative solutions. The whole team participates in trying to come up with creative options for settling property, kids, all of it. And I think people are just generally happier. And they're also happier because they haven't beat each other up in court. The process focuses on going forward, the future.
Solutions.
Right.
Instead of problems.
Right. And as a parent and a divorce lawyer, I think all 3 of us can say this. I don't think I've ever seen a parenting relationship that was made better at the courthouse.
No.
So,
But often they are made to function better and smoother in the collaborative process, because you learn to communicate with each other differently and in a more positive way.
Right.
And another feature that clients really love about collaborative law is that it's private. So all of the negotiations and the information gathering is done privately between the attorneys. Nothing is filed with the court, generally speaking. And there aren't court reporters and bailiffs. And, when you have a hearing at the courthouse, anyone can come in and attend. It's public. So in the collaborative process, we're in someone's conference room, your conference room, our conference room. And it's a much more private and civilized process that people go through. And they're happier with that.
And don't think that you have to be skipping down the hall and holding hands with your spouse to do collaborative. We're not in there singing Kumbaya. I mean, we talk about very difficult subjects. We deal with problems that come up. If there's a problem with alcohol, we talk about it. It's not that collaborative means everybody's just happy and nice and there's no complex or difficult things to deal with. It's the manner in which we deal with them that allows people to really, it's almost healing. They, instead of having the divorce be such a devastating process and so emotionally difficult, it can be more of a healing process handling it collaboratively, I think.
It's more of a constructive process than a destructive process. And it helps rebuild your family from one family into two new families rather than destroying the entire family unit, which is what litigation generally does.
If you want more information on collaborative law, a good place to start is austincollaborativelaw.com. There are links to other websites and information sources on that website where you can go and educate yourself more about the collaborative process. So I think our last topic is litigation, which is really anything except for everything else that we've talked about. So you're kind of naturally in litigation if you haven't elected one of these other alternate routes to get to the end of a divorce. I think typically litigation is the most expensive format that we use for getting people divorced. It of course starts by filing a petition like everything else, and then a lot of times people will have a temporary orders hearing. So you can have a temporary orders hearing with as little as 3 days notice, although I think most of us would say that's not typical that you would go and file a petition and immediately go to court unless it's an emergency.
And in which case, if it's an emergency, we might be doing something like requesting a temporary restraining order or even a protective order. And quite frankly, in most of my litigation cases, the reason we would go to litigation is because of some sort of family violence or danger to the kids. Otherwise, I try to steer my clients away from litigation because I think it just makes the process harder.
I think it's more difficult on your children and on your family, and I think there's a lot of research to indicate that that's the most difficult aspect of divorce for children is the fighting and the litigation. And I think we should even explain litigation a little bit more in a more basic way, which is what we mean when we say litigation is you're actually going to the courthouse and letting someone else make decisions. And just because you don't choose another one of these processes we've talked about doesn't mean you'll end up in litigation. But litigation would be the last resort if you don't resolve the issues on your own through one of these other mechanisms that we've talked about. So really that just means giving up the control, letting a judge make a decision, and you lose the ability to make agreements on your own.
I would say it varies county to county as far as how easy it is to get in front of a judge. In an emergency situation, pretty much in all the counties, we can usually find a way pretty quickly, but it needs to be a true emergency. Otherwise, they're not going to give you time in front of a judge. When we say emergency in the family law context, I think that's something more like domestic violence or parental kidnapping of a child. Those are the two things that really come to mind that are going to merit you getting some time without having been waiting in line, so to speak, for your turn. In Travis County, you can pretty much set a case, I think, at any time, but a lot of times there will be 40, 50, 60 people on the docket, and you might not get reached. You might get told that you need to leave if it's not an emergency. In Williamson County and Hayes County, they're a little bit stricter about how many cases they will allow to actually be set on a given day in front of a given judge. So they actually won't let you even get on their calendar if they don't think there's time to hear you.
I think the last time I had to set a case in Williamson County, it was an enforcement action. We couldn't get on the docket for 6 weeks. That's how long it took us to get a hearing date, and then he only gave us 2 hours.
Right, which is another aspect of litigation, although we all three practice litigation, and I think we would probably all three say we see it as a last resort, not a first resort, and sometimes you do have to go to the courthouse to get things resolved. It's a very inefficient system, and because of the inefficiencies, many of which the lawyer doesn't have control over, like waiting when you get to the courthouse, it ends up being the most expensive by far.
And the prep time that's involved to go to court is just intense and just long. I mean, it's a lot of work to get ready, get your clients ready, know who all the witnesses are, get all the exhibits ready. It's ends up being very expensive.
Very time-consuming.
And I would say better than 50% of the time you do all of that preparation work, and then you get there and end up being able to work out a deal with the other lawyer, or kind of being forced to work out a deal because you can't get in front of a judge. And so they put you on what is called recall, meaning you go out and wait. And during that time, a lot of times things are negotiated. Sometimes it just depends on the lawyers that are involved too. There are a lot of lawyers that if I see that they were going to be opposing, I know we're going to the courthouse. I can try to call them, I can send letters, but they're usually not going to be willing to talk until we get there. There are others that I'm almost positive I can get something worked out with. So that can change retainers that I quote.
Oh, absolutely.
Just depending on who shows up on the other side or who is already there.
And sometimes even when you get reached, the judge will order you to go and try to settle the case even after you've done all the work, done all the prep. You're at the courthouse waiting. The judge calls you in, or the clerk calls you into the court, and then the court orders you to go out in the hall or go in the jury room and try to settle. So then you have more time until you get your hearing, and that happens pretty often, I would say.
Right. Or they pull the attorneys in chambers and basically chew us out sometimes. Why are you here? A lot of the judges they don't want families in the courthouse. They want people, especially with kids, they want people to work it out. And we regularly get ordered to go to mediation, and that's pretty standard, at least in Travis County, that you go to mediation before a final trial. But yeah, they also just order us in the hallway.
Right. And then after all of this, if you do get a hearing, you never get as much time as you want. So especially on a temporary orders hearing, you may want a day and the judge may give you 3 hours. So then you have to decide what is the very most important information to use your 3 hours with, and the judge will know very little about your case and about your children before they make a decision. I think that's one reason why they prefer parties to settle, because they assume they're only going to know a small portion of what there is to know about the routine, the children, the parenting.
Right. Typically when you get to temporary orders, you haven't done discovery yet. Discovery is the information gathering that we do. So typically it would be interrogatories, which are questions that you get to ask of the other side, and they've got 30 days to answer. Request for production, which is document production. Depositions sometimes, which those would be of key witnesses or of the other party. Those can go 6 hours per party. I don't do those in every case.
They're pretty rare in family law, I would say.
Yeah, I actually just recently, we set depositions before our temporary orders hearing. We ended up settling our temporary orders, and I think it was because we had those depositions, and we limited it. We probably did it 3 hours each side, all in the same day. And that case started out, we knew we were going to litigation.
I think I left out one component.
Admissions.
Right. So requests for admissions are the other thing. So it will just say like admit or deny a certain fact in the case. And so that's very time intensive. The paralegal staff, I think generally if a lawyer has paralegal staff, they're going to be doing the legwork on most of that. And then the lawyer will swoop in at the end and review the requests before they go out. And then of course we'll review everything the client has produced. And it's a lot of work for clients too. I mean, we're giving our clients stacks of envelopes basically and saying you've got to have this back to us by a certain date, and then begins the process of the paralegal going through it with the client, and then after that the lawyer. So you can see how it can get really expensive. It's just the sheer amount of hours. All of those things have to be numbered and scanned in and organized to take to court in case you need to use them as exhibits. And like I said, half the time you get there and don't need them.
Right.
Anyway.
Right.
One other thing we haven't mentioned about litigation is that it takes longer. So if you were going to have a collaborative divorce or a negotiated divorce, cooperative divorce, something other than litigation, you may get finished in 6 months, 3 to 6 months, I think we say is the average. Litigation is probably 6 to 12 months and can often go out farther than that if it's really difficult litigation. So it's a lot more time involved before you get your divorce.
Right. And you've heard us say temporary orders. Really, temporary orders is a lot of times it's a Band-Aid, but it's who's going to pay what bills, who's going to stay in the house, or are you going to go in and out of the house, what's child care look like, who's with the children when, those type of things. And what's kind of interesting is you call it a Band-Aid, but then at the same time, most of our cases, whatever happens at temporary orders is close to what it ends up looking like in the end. So that's a little scary if you think about it.
Right.
A lot of times you're rushing in, you're just kind of pasting this together and you think it's a Band-Aid, and that ends up being what sticks in the long run.
Right.
And the difference between going to a hearing on temporary orders versus a final trial is you're walking into that courtroom not knowing who the witnesses are on the other side, not knowing what exhibits, because you haven't done all of the discovery, and so you don't know what the other side is going to be presenting. Versus a final trial, when you've done all that discovery and you've exchanged, well, here's my experts, here's my fact witnesses, you have a much better idea of what challenges and what the other side's argument is going to be. Versus at temporary orders, I've been in temporary orders hearing where I was shocked because things came out that my client failed to tell me, and they weren't good for my client, you know, or your client doesn't do well on the witness stand. For whatever reason. Maybe the opposing counsel is able to really trigger them and make them very angry in front of the judge. And because the judge has this little bit of time, you know, that's not the thing that you want the judge to see, is, wow, this person is really angry.
Right. I would say that many fewer cases go to final trial than temporary orders hearings, though, because if you're setting for a final hearing, then as we talked about earlier, you've gone to mediation, which is very successful, well over 90% statewide. And so the chances are smaller that you would have a final trial than a temporary orders hearing, I would say.
That's true. In Travis County, you probably won't get the same judge on a temporary orders hearing as you will on a final, and that could be a good thing and a bad thing. If you have the client that doesn't do well at temporary orders or things that came out, you probably would prefer not to have the same judge. Whereas in Williamson County, you will have the same judge for the entire case. Hayes, I think it varies. And those are kind of our three main areas where the three of us practice. I've heard of jurisdictions across the state where the judges will limit witnesses to 2 witnesses in a temporary orders hearing, things like that. I don't know of any of our judges here that it's quite that strict or predictable. So
Right. Well, and predictable is the perfect word. Litigation is unpredictable. And, you know, I tell all of my clients and folks that I mediate for, you're handing over control when you walk into a courtroom. The judge has limited time, is going to have a limited understanding of you, your family, your kids, and you're completely out of the decision making. So
and they have huge discretion.
Yeah,
Limited time, but huge discretion.
Right. And also less availability to appeal. Not that we see a lot of appeals, but on temporary orders, you don't have the same type of appellate rights that you do on final. Good morning and welcome. We are here to talk about divorce basics, and these are my friends and colleagues, Amanda Andrae and Melissa Williams. I'm Cristi Trusler. We're all 3 divorce attorneys in Austin, Texas, and we're putting together a webinar to help educate our clients about the basics of divorce, what their options are, and some of the common questions that we get. So you may see some outfit changes, that kind of thing. We're trying to put together an in-depth webinar, and this will be over a series of different discussions that we have. So as I said, my name is Cristi Trusler. I have been practicing divorce law in Austin since around 2000, and I'm board certified in family law, which means I'm specialized in the area of family law. About 90% or better of my practice is divorce. I also do a lot of custody work, and just happy to be here today, and I'll turn it over to Amanda.
Thanks, Cristi.
Just as you drank your coffee.
My name is Amanda Andrae, and I have a firm here in Austin, Andrae Law PLLC. I'm also board certified in family law, and that's my entire practice is family law related. Everything from divorces, custody modifications, terminations and adoptions, and a lot of mediations as well. And I've been practicing for about 12 years in Austin and have only done family law. Melissa?
And my name is Melissa Williams, and I'm also a family lawyer here in Austin. I've been practicing for 18 years, exclusively family law, and all in Austin. And I'm also board certified aspects of divorce, modification,